Hey everybody, thanks for being here tonight. Like Veronica said, my name's Carl Blair. I am TCRP's election protection attorney for this election cycle. And thank you all for being here tonight. So let's go ahead and jump right in. We should be able to get done in about 45 minutes. So let's get started. All right. Can everybody see my screen there?
Looks great, Carl.
Great, awesome. Perfect. So this is the third of our four-part summer CLE series. We try and put on one of these CLE series every 2 years, midterms and general elections like this year. So previously, 2 weeks ago, we did a presentation. Veronica did a presentation with our wonderful partners at Disability Rights Texas on disability access at the polls. And last week, I led a presentation on the counting of ballots, how election returns are canvassed, and how elections are certified in Texas. So on August 19th, and we'll repeat this at the end of the presentation, but on August 19th, we're going to make all four of our recordings available on probably YouTube. That's where we're thinking about putting them. So if you missed one of our previous presentations, or you have a colleague or a friend, somebody that you think might be interested in one of those presentations, starting on August 19th, you can watch them all on YouTube. So, all right. Well, tonight's presentation is, we're calling it part two of our After Ballots Are Cast presentation. And tonight we're going to be talking about recounts, election contests, and audits. So first things first, who are we? We are TCRP. We are a nonpartisan 501c3 nonprofit organization founded back in 1990. We have three programs in our organization. We have one Beyond Borders. They deal with border and immigration issues. We have a criminal and justice program. They deal with criminal justice reforms. And then finally, Veronica and I are in the voting rights team, which also includes our election protection efforts and all of our voting rights litigation. In the EP team, we advocate for Texas voters through every step of the voting process, from registration to casting ballots to the kind of stuff we're going to talk about tonight. All right, so we always like to start with a roadmap. So these are just the three types of issues, the three big categories that we're going to talk about tonight. Again, that's recounts. We're going to start with recounts. We're going to move over to election contests and then post-election audits. And just before we get started, like I did during our presentation on counting, canvassing, and certifying elections last week, I'd really like to thank our law clerk, Tomas Russo, for helping me organize this presentation and really helping me make this presentation easier to follow. So we're going to get kind of into the weeds in the election code. So yeah, Tomas was very instrumental in making this much easier to follow. So great shout out to him. All right, so before we jump into the issues of recounts, I think we should probably take a quick look back at last week's presentation. Specifically, a couple of topics that we talked about last week are also going to be important this week. So the first of those is what methods of voting are allowed in Texas. So voters in Texas are going to cast their ballots using one of three methods. First is your old school traditional paper ballots. Voter marks the ballot, they put the ballot in some type of box for collection and counting later. There's the second option is an optical scan voting machine. And those are machines where voters mark their ballot and then they place the marked ballot into some type of machine where it's scanned and the votes are recorded by the machine. The third option is something called a direct recording electronic machine. And these are going to be the types of devices and voting machines that utilize touch screens or buttons for the voter to actually mark their ballot. And you'll see that they'll come into play a couple of issues in a couple of these issues that we're going to talk about tonight. So the second thing I want to reiterate from last week is what canvassing is. And so canvassing happens after the ballots are counted, and it tallies the total number of votes in each election precinct. The total number of voters in each election precinct who cast a ballot for a candidate or for or against a measure. And then directly tied to canvassing is the idea of a canvassing authority. And simply put, this one's really easy concept to understand. It's just the governmental body responsible for canvassing a particular election. So every every election is going to be canvassed, and every election is also going to have a canvassing authority who actually carries out that canvassing. So for district offices and statewide offices, excuse me, and district offices in the election code in Texas specifically mean both federal and state offices that aren't voted on statewide. So you can think of your member of Congress, you can think state board of education member at the state level. That's what we mean by district offices. And then statewide offices, that's going to be offices like Court of Criminal Appeals justices. That's going to be justices on the Texas Supreme Court, your railroad commissioner, land commissioner, those kind of statewide offices. So for every district office and statewide office, except for governor and lieutenant governor, precinct election returns, so those tallies, the total number of voters from each precinct, they're going to be canvassed by the county commissioner's court. So whichever county we're talking about, that county commissioner's court is going to be canvassing their precincts. And then there's something called county election returns, which is just the sum total of all precinct returns from a specific county. The governor's office is going to canvass those results. If we're talking about a county election, so county judge or county commissioner's court, that specific county's commissioner court is going to be the canvassing authority. And then lastly, if we're talking about any local elections, so think mayor, city council type of elections, whatever the governing body of that political subdivision is, that's the canvassing authority for those elections. So you'll see all three of these pop up a couple of times throughout tonight's presentation. So I just wanted to make sure that everybody had a quick little recap about what these three concepts mean. All right, so let's jump into recounts. The provisions on recounts are fine. They take up all of Title 13 of the Texas Election Code. And so the four categories or the four issues we're going to talk about within recounts. First off, we're going to ask who can actually request a recount. Then we're going to talk about the scope of a recount. We're going to talk about how you apply for a recount or how you request a recount. And then lastly, we're going to talk about how the recount itself is actually conducted. So who can request a recount? A losing candidate may request a recount when one or more of these conditions are met. So they just have to meet at least one of these conditions. So the first is the difference between the losing and the winning candidate's vote totals is less than 10% of the losing candidate's votes. I'm not great at math, but I believe that would mean that if you had a candidate who received 1,000 votes and you had another candidate who received 900 votes, something like that. That actually, nope, that wouldn't even be it. But, if say you had 1,000 votes for candidate A and 999 votes for candidate B, that candidate B in that case would be able to request a recount under this first bullet point. Second situation that a candidate can request a recount for would be if the election returns, and those are those precinct and county election returns we talked about a couple of slides ago. If the election returns show that the losing candidate is entitled to a place on a runoff ballot or tied for nomination or election to a place on a runoff ballot. Third is if the total number of votes received by all candidates is less than 1,000. And the fourth is something called counting errors. And that one's a little bit more detailed. So we're going to explain that on the next slide. But I want to note just before we keep going, that a losing candidate can obtain a recount of electronic voting system results, so your optical scan results and your direct recording electronic results, even if their race doesn't fall into one of these categories. And in case you were wondering if there are any situations in which a recount is automatic in Texas, the answer is actually yes. But an automatic recount can only take place when the vote is exactly tied. No other situation is an automatic recount going to be allowed in Texas. So. All right, so let's dive into counting errors a little bit. And if you see anything bolded and italicized, that's something that we really want to bring to your attention. So what do we mean by counting errors? Well, the Secretary of State can actually require a recount after they certify that, quote, counting errors affecting the election occurred in one or more election precincts in which paper ballots were used. So just again, to emphasize, this is only in precincts where paper ballots were used. So if the precinct used optical scan or direct recording electronic voting machines, this counting errors category for requesting a recount doesn't exist. All right, and so to seek a recount on this specific ground, a candidate has to submit an affidavit from a precinct election official stating that certain votes were either counted or not counted erroneously. So there has to be an affidavit from a precinct election official saying that there were problems with the counting, there were counting errors in the precinct that they were working in. Opposing candidates, so for instance, the winning candidate of that race, they can actually submit an affidavit to rebut this assertion. So the losing candidate could say, here's an affidavit that says 10 votes weren't 10 votes were not counted correctly, or they were counted erroneously. The winning candidate or any other opposing candidates, it could be another losing candidate if it's a runoff. I'm sorry, if it's like a primary type situation where more than two people are on the ballot. But any other opposing candidates can file their own affidavits from precinct election officials rebutting that assertion that there were counting errors. So the Secretary of State may certify a recount on this basis only if they determine from uncontradicted statements based on undisputed facts in the submitted affidavits and from election returns that they view that certain votes cast were clearly erroneously counted or not counted. So it's a very high standard. This counting error standard is very high. And in fact, the Secretary of State may not certify a recount on this counting errors basis if there are any facts that are disputed or any facts that raise unresolved legal questions as to whether counting errors occurred. So really the point of this is that one, it's only applicable to precincts where paper ballots were used. And two, the standard for the Secretary of State to certify a recount on this basis is a very high standard. All right, so let's talk about the scope of a recount. So for any offices or measures without a state level canvas, so think your city elections, local school board elections, county offices, precinct offices like a justice of the peace, those type of offices. The request for a recount must include every election day precinct in the territory from which the office is elected, unless the ground is counting errors. So that's an important parenthetical there. If you're using any of those other categories except counting errors, the request has to include every election day precinct that would vote on that particular office. But if we move over to offices or measures with state level canvases, so again, that's your statewide offices and your district offices, an initial recount of votes cast in a particular voting system. So if you could request a recount in optical scan precincts or a recount in direct recording electronic precincts. But in an initial recount of votes cast in a particular voting system, it may include any one or more counties covered by the election, but it must include all the election precincts in which a particular voting system is used in each county recounted. So to kind of clarify that, if you have a congressional district and it covers, let's say, five different counties, right? So it has precincts that are in 5 different counties. If you are requesting a recount of that race, you could say, I want all of the optical scan ballots in Harris County recounted, or I want all of the direct recording electronic precincts in Fort Bend County, our neighboring county to Harris County. But if you do that, if you specify that much, then you have to include all of the election precincts in which a particular voting system is used in each county. You can't just say, well, I only want precinct 1 and 2 in Harris County. You have to say, okay, all of those type of systems or all of those precincts. If you're talking about paper ballots, that has to include each election precinct in which paper ballots were used in the election. Again, unless the ground is counting errors. So that same thing holds true. You can't just pick and choose which precincts you want to have recounted. If you pick a specific type of voting system, paper ballots, optical scan, direct recording, you're going to have all of those precincts using that system recounted. All right, so what is the actual process of applying or petitioning for a recount? So the recount petitioner the person who's petitioning for a recount, they have to file a document that states which race they seek a recount for, their grounds for seeking a recount, and then the specific precincts which they want to be recounted, and indicate which method is used in each precinct, right? So going back to that scope, again, this is where you can say, I want all of the precincts in a specific county that use a specific voting method recounted. And this application for a recount, or you see the terms application for recount and a recount petition are both used kind of interchangeably. But this application for a recount is where you would specify which counties, which voting systems you're going to want to use. On the flip side, any recount petitioner may submit a document that withdraws their request for a recount. It requires the same information listed above. And what's important about the withdrawal is that on receipt of this withdrawal, the recount is immediately canceled. And it's treated as if it had never started, it didn't take place, it's just immediately canceled. All right, so at this point in the process, we've gotten our recount petition written, it's drafted. Where do we actually deliver that to? Who do we need to send that to? So what's the place for delivering the recount petition? So the authority to which a petition for a recount must be submitted varies depending on the office that's at stake. So here's where it gets a little tricky. So if you have only one local or county canvassing authority, the recount must be submitted to the presiding officer of that canvassing authority. So that one's pretty straightforward. If you are trying to request a recount for a mayoral race, that's going to go to more than likely a city council. If it's a county judge race, that's going to go to the county commissioner's court. All right. So what about situations where we have more than one local or county canvassing authority, but no state level canvass? Well, in that case, the recount petition must be submitted to the presiding officer of each local canvassing authority within whose jurisdiction a recount is desired. And this kind of goes back to what we were saying a minute ago, where if you have some type of office that has multiple counties or maybe multiple cities, you could say, I actually only want to recount in this specific county or in this specific city. And then if we move up the chain, if you will, to state level canvassing, the recount petition must be submitted to the presiding officer of the final canvassing authority. So that's generally going to be the governor's office. But as you'll see on the next bullet point, if we are actually talking about an election for governor or lieutenant governor, the recount petition actually has to be submitted to the Secretary of State. All right, so now we know where to send our recount petition. We know who's supposed to get it. What's the timing? What's the timeline that we have? So a petition for an initial recount must be submitted by 5 p.m. of the third business day after the date the appropriate canvassing authority completes its canvass of the original election returns. All right. So just for reference, for the November general election later this year, all of the state canvasses must be completed between November 23rd and December 8th, while all county and local canvasses are going to have to be completed between November 8th and November 19th. So you'll see this a lot in the election code if you ever dig into it. There are a lot of date ranges. You'll see a lot of things that say like this, 5 p.m. of the third business day after the date at which something else happens. But yeah, so this way we have a little bit of a date range. So state canvasses, November 23rd to December 8th. Local and county canvasses, November 8th through November 19th. So a petition for a winning candidate in response to an opposing candidate's petition must be submitted not later than 48 hours after receipt of the notice of approval. So what's going to happen is that authority on the previous page that we talked about, whether it's county commissioner's court, city council, governor's race, once they actually get the recount petition, they're going to make sure that it fulfills all the legal requirements. And if it does, they're going to give approval to that. And then we'll talk about this a little bit later, but they're also going to send notice to all of the other candidates who are in that election, or specifically in the election for that same office. So it's after that receipt of the notice of approval that triggers the winning candidate's ability to not the winning candidate's ability, but the winning candidate's timeline for submitting any other petitions that they have at that point in time. If the deadline for submitting the petition for an initial recount falls on a weekend or a legal state holiday, the deadline is just extended to 10 a.m. of the next regular business day. And then if the recount petition does not comply with the requirements, the petitioner may amend the petition no later than the deadline for initially submitting the petition, if they got the petition in early, for instance, or 5 p.m. of the second day after receiving a notice of a defect, whichever of those two is a later date. All right, so we know who to send it to. We filled it out. We got it in on time. Who actually pays for the recount? What is the cost of actually requesting a recount? So recounts must be accompanied by a deposit of $60 for each election day polling location or precinct, whichever of those numbers results in a smaller amount, in which regular paper ballots were used, and $100 for each election day polling location or precinct in which an electronic voting system was used. So, for instance, Harris County frequently has, where I am, I'm in Houston, we frequently have 700 plus election day polling locations. So if you wanted to do a recount of the entire city of Houston, for instance, that's talking about what, $75,000 at least. So yeah, it can be expensive depending on how large the recount is. And then also for early voting polling places, each of those early voting polling places in which a voting machine is used is treated as one election precinct. All right. Last part of our discussion about recounts is how is it actually conducted? How is the recount itself actually conducted? So the presiding officer for each local canvassing authority, remember that's just going to be the governmental body who's conducting the canvass. The presiding officer for each local canvassing authority that contains a precinct subject to recount supervises the recount for those precincts. There also, you might see reference to a recount supervisor. That's just this presiding officer of the canvassing authority. So the recount supervisor appoints a recount committee of at least 4 members and then appoints one of those members to chair the committee. And the chair of the recount committee the chair of the recount committee has the power of an election judge to determine which ballots should be counted or which should be excluded from the recount itself. If there are any recount members who execute an affidavit alleging that a vote was improperly counted or not counted, the recount coordinator, that's the authority to whom a recount petition was submitted, they may actually order a reexamination of the disputed ballots. So I mentioned briefly notice of recounts. The recount supervisor has to give personal notice of the recount to the petitioner and all opposing candidates. You see the phrase initial recount pop up a couple of times on these slides. An initial recount is exactly what it says. That's an initial recount. There are also supplemental recounts. You may hear some situations where a race goes through more than one recount. But this is just the initial recount that we're talking about here. This is the one that triggers the initial recount. But the recount supervisor shall give personal notice of an initial recount to the petitioner and all opposing candidates. And so that notice must include the time and place where the recount is scheduled to begin and the number of counting teams designated for the recount, if applicable. So if there's only one counting team, that may not need to be noted, but if there are going to be more than one, 2, 5, 10, however many, that's going to have to be on there as well. And the notice actually has to be given at least 18 hours before the recount begins, unless each person entitled to the notice agrees to begin at a specified earlier time. Each candidate for an office subject to recount has the right to be present themselves or have watchers present. Political parties may also have watchers present at recounts. And generally, the same rules governing poll watchers are going to govern recount observers as well. And then the determination of the results of the recount and notice of that determination. When the recount coordinator receives notices of the results of a recount from all of the recount supervisors, the recount coordinator shall promptly determine the results. A notice of the results of the recount will be given by the recount coordinator. Again, just like giving notice of the recount itself, it's going to have to be sent to the petitioner and each person entitled to notice. And this is also ties back in this last bullet point on this slide also ties back into last week's presentation. So just very, very quickly, once ballots are counted, once election returns are canvassed, at that point in time, what's known as a certificate of election is filed or is printed and sent out. And once that is taken care of, then an election has been certified. However, if a recount is pending, then no certificate of election can actually be issued. So if a recount's going on, the final certificate of election is not going to be issued. All right. And so with that, we're going to leave the world of recounts and we're going to move into election contests. And that's included in Title 14 of the Election Code. So we're going to start with jurisdiction. We're going to move into evidentiary issues. And then we're going to talk about the actual process of conducting the election contest. All right, so let's start with jurisdiction. So as you may have noticed, these things frequently depend on what specific race is being recounted or what what race is being contested. Same with jurisdiction for election contests. Let's start with the state Senate and state House. They have in joint session exclusive jurisdictions over contests of a general election for governor, lieutenant governor, comptroller, land office commissioner, or attorney general. All right. The state Senate has exclusive jurisdiction over a contest for state senator. The state House, likewise, has exclusive jurisdiction over a contest for state representative. The governor has exclusive jurisdiction over a contest for the election of presidential electors. And then district courts have original jurisdiction for the remainder of non-federal elections. And then, a very familiar setting to us attorneys, Court of Appeals has appellate jurisdiction over a contest originating in a district court. And so the scope of the authority in these types of situations, the tribunal hearing an election contest may inspect any ballot boxes, any voting machines, any equipment, and any ballot materials as necessary to conduct its hearing. So that's a very broad scope of authority there. All right, so let's move into the evidentiary issues. So let's talk about the scope of the inquiry. So the tribunal hearing the election contest, whether it's the state Senate, state House, district court, governor's office, whoever's hearing the election contest shall attempt to ascertain whether the outcome of the contested election, as shown by the final canvass, is not the true outcome. Because either illegal votes were counted, and illegal votes are simply votes that were not legally countable, or an election officer or other person officially involved in the administration of the election prevented eligible voters from voting, failed to count legal votes, or engaged in other fraud or illegal conduct, or made a mistake. The evidentiary issues, moving on a little bit farther down, a voter who cast an illegal vote may be compelled, after the illegality has been established to the satisfaction of the tribunal hearing the contest, to actually disclose the name of the candidate for whom they voted, if the issue is deemed relevant. And if the number of illegal votes is equal to or greater than the number of votes necessary to change the outcome of an election, the tribunal may declare the entire election void without even attempting to determine how individual voters voted. So, we have this concept of the secrecy of the ballot in not just Texas, but the United States. And this is one of the situations where that secrecy can be kind of penetrated or burst. But yeah, so in this type of situation, a voter who casts an illegal vote can actually be made to disclose who they voted for. All right, so if an examination of ballots is needed in an election contest and the ballots are lost, destroyed, or in some other way beyond the reach of the tribunal, the voters who cast the ballots may testify as to how they voted. You'll notice, as opposed to the last, this is a situation where the voters may testify, as opposed to the previous slide that said that voter shall testify. So that's a little bit of a difference there. If the tribunal hearing an election contest can ascertain the candidate or side of a measure for which an illegal vote was cast, the tribunal subtracts the vote from the official total for the candidate or side of the measure. as applicable. So if they can say, well, candidate A got an illegal vote cast for him, that vote is going to be just subtracted right from candidate A's total. If the tribunal finds that illegal votes were cast but can't ascertain how the voters voted, the tribunal shall consider those votes in making its final judgment. All right, so now we're going to shift into the two different types of contests that we're going to talk about tonight. And the first is contests that are held in the state legislature. And this is going to be whether it's a joint session of the Senate and the House, or whether it's exclusively in the Senate or exclusively in the State House. So what's the form and content of the contest petition? The petition, again, must state the grounds for the contest. It must be filed with the Secretary of State not later than the 7th day after the date election records are publicly available. This year, that date is going to be November 27th, or 7 days after the official result of the contested election is determined. An election record shall be available not later than the 15th day after the election, which is November 20th this year. So how is a contest actually conducted in the state legislature? Well, the presiding officer of the chamber with jurisdiction refers the petition to a committee. And after conducting its hearing as governed by the chamber's rules, the committee issues a report as soon as practicable. The entire chamber then considers the report and they declare the outcome of the contest. The committee can actually refuse to hear testimony or other evidence presented in person by the parties if the contest discovery master determines that the contestant's petition is frivolous or otherwise groundless. So that's a way that they can refuse to hear evidence that the tribunal, in this case the committee, deems to be frivolous or groundless. All right, and so then we're going to get into something that's probably a little bit more familiar for us attorneys on the call, and that's contests filed in district court. So we're going to start with venue. The venue of an election contest for a statewide office, other than those over which the state Senate and state House have exclusive jurisdiction, is in Travis County. The venue of a contest for an office less than statewide, that's filled by voters of more than one county. So we're going to talk about some of those district offices that we talked about, congressional races, state board of education races. If there's more than one county that votes on those, the venue is going to be in the county in which the contestee or any of the contestees resides, if their residence is in the territory covered by the election, or in any county wholly or partly in the territory covered by the election. And then the venue of a contest for an office filled by voters of only one county is, that one's pretty clear. That's going to be in that specific county itself. All right, so the filing period for a petition for a contest filed in district court. A contestant may not file the petition in an election contest earlier than the day after election. And a contestant must file the petition not later than the later of the 45th day after the date of election records are publicly available, January 4th, or the official result of the contested election is determined. And just to note, the district court may require or at least permit any one or more candidates in a contested election to be named as a contestee, or may permit the candidates to intervene on the side of one of the contestees. All right, and so here's some just final process issues for election contests. Deciding the contest. If the tribunal hearing an election contest can ascertain the true outcome of the election, the tribunal shall declare that outcome. So if they can tell, to the tribunal's satisfaction that candidate A won the election, then they are going to determine that that's the outcome. However, if they cannot ascertain the true outcome of the election, the tribunal declares the election void and can order a new election. We actually saw that recently here in Harris County. After the 2022 elections, 30 different election contests were filed by losing candidates. 29, they were all heard by the same visiting judge. 29 of those contests were actually either withdrawn by the petitioners or the contestees, or the judge was ruled against them, threw them out. However, the very last one, it happened just a couple of months ago, I believe in May. The judge ruled that he was unable to determine the true outcome of the election, voided the election, and ordered a new election be held this November. I believe that's currently in appeals, so we're not actually sure how that process is going to play out. But this is not something, it's not something that happens very often, but it is something that does happen sometimes. And so, what is the effect of election contests on canvassing and certification? We saw that recounts put a pause on certification. However, election contests don't do that. The timing of an election contest does not affect canvassing and certification at all. While the contest is actually pending, the result of the election shall be determined and certified as if the contest had not been filed at all. So for canvassing and certification purposes, whether an election contest is filed or not doesn't actually matter. All right, let's move on to our final topic for tonight, and that's post-election audits. They are found in Chapter 127, subchapters H through J of the Texas Election Code. So there are three types that we're going to talk about today. First is what we're going to call a county level partial count. That deals specifically with electronic voting systems. Then there's randomized county audits, and then there's something that actually is going to be required statewide starting on September 1st, 2026 for statewide elections, and that's something called a risk limiting audit, and we'll get into what that is in just a couple of slides. So first off, just to ask the question, what is a post-election audit? Well, the U.S. Election Assistance Commission gives a really good definition. Post-election audits are used to verify that ballots were tabulated correctly. They generally require a local election official to audit a percentage of its tabulation equipment, so your voting machines, and ballots or ballot images. They can be set up in a way that the local election official has to audit a specific percentage of jurisdictions. Like maybe they have to audit 1% of the precincts in their jurisdiction. Or another option is that risk limiting audit of ballots, which again, we'll talk about in just a couple of minutes. So just to reiterate, there are three different types of post-election audits that are required or will be required starting on September 1st, 2026 under the Texas Election Code: county level partial manual counts, randomized county audits, and risk limiting audits. All right, so let's start with the county level partial manual counts of electronic voting system ballots. It's a mouthful, but generally what it means is that a general custodian of election records, so that's going to be your county clerk or your elections administrator, in counties using optical scan voting machines, must conduct a manual count of all the races in at least 1% of all precincts, or at least 3 precincts, whichever is greater, chosen at random to ensure the accuracy of their electronic voting system. So this recount must begin no later than 72 hours after polls close. That's November 8th this year, and must conclude within 21 days after the election, November 26th. So in a general election for state and county officers, any primary elections on a proposed amendment to the state constitution, or any other statewide measure that the legislature submits, the Secretary of State selects not more than 3 offices and not more than 3 propositions to be audited, and informs the counties of which races and which offices and which propositions must be audited, not earlier than the day after election day. So you kind of have 2 things going on here at once. You have the county clerk or elections administrator who's going to have to audit at least 1% of all their precincts, and then they're also going to be auditing whichever offices and propositions the Secretary of State selects. And just as a general note, guidance from the Secretary of State requires counties to include early ballots as well as election day ballots in their audit. It's not found in the Texas Election Code. It's not expressly stated in the Election Code, but that is how the Secretary of State interprets the Election Code provisions about audits. All right, so let's dive a little bit deeper. So on selection or notification of the precincts to be counted, the general custodian of election records, county clerk or elections administrator, they post a notice of the date, time, and place of the actual count. Each candidate in the election is entitled to be present at the count or have a representative present. Not later than the 3rd day after the date the count is completed, which would be, we have a date range, but that would be no later than December 2nd this year. The general custodian of election records delivers a written report of the results of the count to the Secretary of State's office. And I want to just note here, even though it says that it's for electronic voting system ballots, and we know from our previous discussion that there are two different types of electronic voting systems in Texas. This procedure specifically does not apply, or it expressly does not apply to the tabulation of electronic voting system results for any system that uses direct recording electronic voting machines. So this whole county level partial manual count only applies to optical scan voting machines. So no paper ballots, no direct recording electronic voting machines. I also want to note here that the Secretary of State has the authority to conduct a count of any portion of any number of ballots from any precinct using optical scan voting systems at their discretion. And the count must be conducted at any time during the period for preserving the applicable precinct election records, which is at least 22 months after election day. So at this point in time, we're pushing this all the way into, late 2026. So for that 2-year period or so, the Secretary of State has authority to conduct, again, at its discretion, a count of any portion of those ballots. And then the general custodian of election records is entitled to be present at a count such as this that's initiated by the Secretary of State. All right, so let's move on to randomized county audits. So immediately after the uniform election date in November of an even numbered year, so that's going to be your midterm elections and your general elections. So immediately after November 5th this year, the Secretary of State conducts an audit of the elections held on the uniform election date in 4 counties during the previous 2 years. So for this next 2-year cycle, we can go back to 2022 and go forward to 2024. It's going to cover those that 2-year period right there. So the Secretary of State's going to pick 4 counties to do that audit for. So the counties have to be selected at random, but 2 of the counties must have a population of less than 300,000, and 2 of the counties must have a population of 300,000 or more. And a county that's selected in the most recent 2-year audit cycle may not be selected in the current audit cycle. And these audits are actually paid for by the state and not the county. In fact, the counties are actually expressly prohibited from paying for these audits. So if not later, this part's a little tricky. If not later than July 31st of the first odd numbered year following the commencement of a randomized audit. So for our purposes today, this is July 31st, 2025. If no later than July 31st, 2025, the audit findings demonstrate a, quote, recurring pattern of problems with election administration or voter registration in an audited county, the Secretary of State shall publicly release their preliminary findings from the audit. They shall recommend the county for administrative oversight of their elections or of their election administration or voter registration. And they may conduct an audit of other elections held in that county in the previous 2 years, whichever elections or however many elections the Secretary of State deems necessary. So counties definitely don't want to get on the bad side of one of these randomized county audits. All right, and so let's jump to the final topic we're going to talk about tonight, and that's what are risk limiting audits. So risk limiting audits are a fairly new concept. Colorado was actually the first state to implement them back in 2017. And the Colorado Secretary of State actually describes a risk limiting audit as, quote, a post-election audit that gives a statistical level of confidence in the outcome, that the outcome of an election is correct. So what's very important to understand about risk limiting audits is the concept of the risk limit itself. And the risk, again, from the Colorado Secretary of State, the risk limit itself tells us the probability that the audit would correct a wrong outcome. They give an example. An audit with a 5% risk limit means that if an election has the incorrect reported outcome, on average, 95 times out of 100, the risk limiting audit would catch that incorrect outcome and correct it. And then, as I mentioned previously, starting on September 1st, 2026, these risk limiting audits will be required for every county in Texas for all elections containing a race or measure that is voted on statewide. So hopefully this last slide kind of clarifies this process a little bit. There was actually, since 2022, the Secretary of State has been running a pilot program on risk limiting audits. And this is a procedure that the Secretary of State's come up with. It kind of shows the overall procedure and practice here. So the blue boxes on top are the actions that the county takes. Golden, orangish boxes in the middle, that's the action that the state takes. So the county creates what's called a ballot manifest. It has a list of the ballots and the votes that are cast on those ballots. They upload that manifest and results and send that to the Secretary of State's office. The Secretary of State's office creates a list of random ballots from that ballot manifest. They send that list back to the county. The county retrieves the specific ballots that the Secretary of State's office requested. They hand count those ballots. They send those results of the hand count back to the Secretary of State's office. They use math that's way beyond me to calculate whether or not that risk limit that we talked about, whether that target goal is met. And if it's met, the recount's over, or the audit's over, sorry. If it's not met, then they create a new list of random ballots, and the process picks back up from there until that risk limit is actually met. So, and with that, that is the last slide I have. So for the next 5 minutes or so, we've got about 5 more minutes left. I will hand the mic to y'all. If you have any questions, any clarifications, any issues you wanted to go back about and talk about again, floor is open. All right, folks. Well, probably should have shared my screen for one more slide because we have one more slide that might interest y'all, and that is there we go, course number. So here's the course number, 174-244-713. We just ask that you self-report your credit hours to the state bar. You can also use that QR code there, and it'll take you straight to the website. And like I mentioned at the beginning of the presentation, starting on August 19th, we'll be posting all 4 of these presentations online. You can access them on demand if you wanted to. For instance, if you missed last week's presentation on the ballot counting process, you want to get caught up on that, watch that. We're going to update those videos with the new CLE course numbers for the on-demand versions. And again, please feel free to share that information with anybody that may be interested. So, all right, and I'll leave that up there, leave that course number up there on the screen for another minute. But that's it. So if there are no questions, thank you all so much for being here. And if you ever have any questions about these topics or anything, you can always reach out to our team. And thank you so much. Our next presentation is going to be on Tuesday, August 13th, 6 p.m. Central again. I'm going to be doing a presentation on language accessibility at the polls with our fantastic partners, Lily and Alice from Asian Texans for Justice. So definitely hope to see y'all there. And thanks again for being here tonight.